Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, 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 all persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, be seated, please. All right, first case we'll hear this morning is United States versus Jones, and Mr. Wellman, we'll hear from you.
Your Honors, good morning, and may it please the court. I'm here on behalf of Mr. Naeem Jones regarding a supervised release violation from October of 2024. Our primary issue, is whether Mr. Jones, in the petition alleging the violations of supervised release, provided Mr. Jones adequate notice of a criminal law violation, a grade A or grade B violation versus notice of only.
Well, the issue's probably a little bit different, I think, if I understand it correctly. He was clearly charged with a grade C violation, right?
Yes, Your Honor.
It seems to me the issue then is whether the district court erred in sentencing him something else.
Yes, Your Honor, I agree with that.
And the court did, right?
The court found a grade B violation.
And so you need a new sentencing hearing, right?
Yes, Your Honor.
All right. How about the issue on Section 3583?
The reimposition of supervised release?
The length of the sentence.
Yes, Your Honor.
It looks like under the statute it's too long.
I agree, Your Honor. I believe that the maximum would have been the 60 months less his term for, this would be for the count two.
Count one is 36 months less 19.
So that would be.
Count two is 60 months less 1.
Correct, Your Honor,
Which
yes.
would have been 41 months, but he got 50 months. He would have been allowed to be sentenced to 41 months, but he was sentenced to, in excess of that, to 50 months, so it was an error.
To 60 months, Your Honor, the full 5 years, and the court did not
Right.
less
It depends whether you aggregate. If you don't aggregate, he was sentenced 1 month too long. If you aggregate, he was sentenced 41 months too long.
Right.
Yes, Your Honor, we would submit that the 41 would be
All right,
the.
you have anything else to present?
I do not, Your Honor.
You did a good job.
Thank you.
Good morning, Your Honors. May it please the court. Carla Painter on behalf of the United States for the Middle District of North Carolina. Based on the court's previous questions, I can tell I have my work cut out for me.
Well, you can argue otherwise, but it looks to me that if you look at the charge, the written charge for violation, he was charged with violating the failure to test, level C. He was not charged with possession. He could have been charged with possession, but he wasn't. There is a separate condition which says violating a federal law or state law is a violation. He was charged under that for counterfeiting, having counterfeit money and driving. But on this charge, he was simply charged with failing tests. That's C, right?
So, Your Honor, it was listed as failure to test. Importantly, the petition didn't assign grade levels to any of those violations. The supplement did, and we relied heavily on that. And
Well, the supplement is just the probation officer's advice. I mean, it's not the charging document.
Your Honor, when the issue is notice, and
It's
we're
not
talking
notice.
about.
The question is, you're charged. It's like an indictment or a complaint. It seems to me, if you wanted to amend it, but the notice is provided in that document. Now, if the probation officer misinterprets it and says the court could find that he also possessed, then they could go back and recharge him. But they can't just automatically, based on this collateral advice to the judge as to what's involved, which is an error, say that the charges are changed.
Your Honor, I would invite this court to review this court's decision in Hanel. It's 794 Federal Appendix 325. In that case, the probation office specifically designated the violations as grade C violations. There was no mention in the supplement anywhere of a grade B violation. Now there, the government filed an independent notice that it believed there were grade B violations in play. But this speaks to your Honor's question in the issue of whether or not the probation office petition reflecting a grade C violation is determinative for due process considerations. This court easily determined it was not, because the government had indicated there was a grade B violation. Here, what the government's notice accomplished in Hunnell, the supplement of the petition accomplished for Mr. Jones.
What is a supplement? Explain it to me.
So the supplement specifically lays
Well,
forth.
what is it as a category? What kind of a document is it?
It's filed separately under seal, but at the same time as the petition. So when the
I
petition.
know, but it's intended to what? Explain to the court what it's all about?
And to provide the probation officer's recommendation and the options statutorily and the policy statements. Importantly, the issue here is
Was it like a briefing document?
Yes, Your Honor. It essentially lays out the facts, the defendant's history of compliance on supervised release, and there is a
And
section.
in this case, there was an error. I mean, in this case, the probation officer inadvertently called it a B violation when the charge was clearly a C violation.
Your Honor, this court's decision in United States versus Battle tells us that testing positive on numerous occasions constitutes a grade B violation. Now,
Of course, I agree with you, and he could have been charged with that. I was surprised he wasn't. The very first charge was violation of federal or state law. And under that, you listed, or the probation officer listed, possession of counterfeit money and driving. Counterfeit money was thrown aside and the driving was all that was left. It was just as easy to say possession of controlled substances in that too, which would be a violation of law. But they didn't charge that.
That's correct, Your Honor.
They charged that he tested positive.
That's correct, Your Honor. And the probation officer certainly could have listed possession of a controlled substance in the petition.
It's like
but-
a gotcha. You want to say the bench memo that the court was given by the probation officer said it was a B, and the court relied on that and called it a B. But the court failed to look at the charge. And I don't know, is that fair to the defendant?
Respectfully, Your Honor, the supplement only listed one grade B violation. That did not refer to the first violation
Well,
at all.
why? Can you actually, this is such an odd case, but can you tell me why that is? Why, if you want to list a grade B violation in the supplemental report, why didn't they just list the one that's actually charged?
Your Honor, I'm not sure what the probation officer was thinking. Perhaps she was under the impression we're talking about a new criminal conduct. The government might not put on evidence to prove that new criminal conduct if it can accomplish the same thing through a grade B violation. And I just want to point out the supplement only listed that controlled substance use. And it specifically stated this qualifies as a grade B
Yeah,
violation.
I'm just saying that seemed odd, given that he was actually charged with a different grade B violation. Can I ask you a question? Because I think there's this sort of notice question that you're raising, but I have a related concern about fairness to the defendant here. The district court makes its finding of a grade B violation, or makes its findings based only on what the defendant admits to at this hearing. And what the defendant admits to is the grade C violation. The district court says, here's the violation, basically reads it as charged. He admits to that. And then the district court relies on that admission for sentencing. So whatever anyone might have thought about what could have happened at this hearing, what the government might have tried to do, the only thing he admitted to was the grade C, and that's the only thing the district court relies on for sentencing. So there's no finding here of a grade B violation, as far as I can tell.
Your Honor, as the revocation hearing was proceeding, the government moved to dismiss violation 1 early on. Before we even started,
Yeah.
the court asked defense counsel, have you read the petition and supplement, and have you discussed it with your client? He said yes. He said, are there any objections? Again, this is the petition and the supplement. No objections. So then we go through the revocation hearing. We dismiss violation 1, and that's the counterfeit instruments. We have admissions on violations 2, 3, and 4. And before the judge even announces his sentence, he said, based on that controlled substance use, the guideline range here is a grade B violation.
You're skipping the whole dialogue where he read the charge to the defendant, didn't he?
Yes, Your Honor.
He read a grade C violation to the defendant. He read it word for word, didn't he?
Yes, Your Honor.
And the defendant admitted it, and that provided the basis for revocation, didn't it?
It did, Your Honor. Before announcing or before proceeding, the court specifically stated, after dismissing violation 1, now defense counsel, I believe we have a grade B violation here based on all of these felonies, this controlled substance use. He specifically asked defense counsel, any objection? No. This is after violation 1 has been dismissed. And again, the supplement is only talking about the controlled substance use as a grade B violation.
Substance abuse is a grade B violation, but he wasn't charged with it. And the point that Judge Harris is making is a mighty powerful one, because I would be inclined to say the defendant is entitled to rely on the charge made, but not if there was any confusion created by that bench memo, so to speak, the supplement that the probation officer wrote. That was totally clarified, because the court then, in total clarity, read the charge and asked him how he pled to that. And the charge was a grade C violation that he read. He actually read verbatim from the charge.
Right, he read the violation,
Yeah.
Your Honor.
And that's what was the basis for revocation.
Right, but we're talking about a grade B violation. I mean, the court specifically read the petition and the alleged violations.
And
but
the
there was-
court then thought that that exchange constituted a grade B violation, which was error. And the court was obviously had picked it up in the supplement somewhere. But the court read the charge, and the plea by the defendant was to that charge. And then the court said that's grade B. Right? That's what happened in the sequencing?
Yes, Your Honor. The court did clarify this is a grade B violation. Now, if there was any...
And that was error. Because
It
the
was-
only antecedent to this was the charge the court read and to which the defendant pled guilty.
Your Honor, the issue is due process, and we're talking about the revocation context.
No, we're
The
talking
issue is...
factually. We're not talking a due process notice or anything else. We're talking about how the defendant was charged and how he responded and what the court said. So the court said, I charge you with, and it quotes the charging document. The defendant pleads guilty, and the court then says this is a grade B violation, and therefore your sentence as follows. That's the sequence. The error in that is the conclusion that that was a grade B violation.
I disagree, Your Honor, respectfully, because as this court tells us in United States v. Battle, repeated positive drug tests equates to possession.
Of course it does. It's obvious. You could have charged that. You don't have to charge every violation.
Your Honor, I would again refer this court to its decision in United States versus Hunnell. I believe we have similar facts, and in fact,
This
in
is
this...
not a legal issue to be decided by other cases. This is a question of what happened. I mean, I don't understand. All right, you can go ahead.
The defendant was aware of the grade B violation per the supplement. There was only one policy statement, one guideline range calculated there. That was grade B. To the second issue Your Honor discussed, the issue is whether or not we aggregate the sentences. I'd like to draw the court's attention to its decision in U.S. v. Actor. It's AKHTER 773, Fed Appendix 707. That was decided in 2019. The reason that matters is because it tells us when the district court sentences on two different counts. The term of imprisonment for one count does not run for the supervised release of another count. And you were correct, Judge Niemeyer, we're talking about a difference of 60 months versus 59 months.
I mean, I don't know the answer to that, but you don't aggregate the sentences, it would be 41 months difference. If you did not aggregate them, with respect to the second count, it would be 1 month.
That's correct, Your Honor.
But that, yeah,
And in this instance, where the district court specifically signaled its intent to impose separate sentences on the separate counts.
fair enough, yeah.
Right, and to the extent there was error for count one, we're talking about, that was the 36-month supervised release, 19 months imposed. Any error in that regard was subsumed by count two, because of course, the supervised release will be running concurrently. If there are no.
But it's still an error, right?
Yes, Your Honor, but
59 months is not 60.
you're correct, Your Honor, but in this case, we're under the plain error analysis. So was there error? Yes. Was it plain? Yes.
Yes.
But did it affect the defendant's substantial rights, and did it undermine the integrity of the judicial proceedings?
Let me ask you
I'm
something.
sorry.
Do we impose an additional month sentence on the ground that we don't think it's substantially affected his rights? I mean, it's a strange argument to make. He's in prison another month, and the argument you would make is, oh, that's not long because of versus 60 months. But the question is, isn't it pretty serious right to be in prison when you're not supposed to be?
Your Honor, it is, and that's what this court relied on in Maxwell in determining that there was a substantial rights violation. Here, it's not prison. He could have been sentenced.
And that's only if we think they run consecutively. If they run concurrently, it's far more than a month.
Your Honor, the supervised release will run concurrently. The issue is how much do we
Well,
deduct based on the
right.
prison time imposed?
But I calculate it as the length, based on the statute, the length of a term of supervised release shall not exceed the term of what was authorized and then less any prison term. And that's, to me, here is 60, the 60 months minus 19 is 41 months, and he was sentenced to 50 months. So that's 9 more months, not 1 more month.
Your Honor, on count one, there was supervised.
Well, if that calculation is correct, would you agree that 9 months impacts his rights? 9 more months, 1 month wasn't good enough. What about 9 more months?
Your Honor, in this court's decision in Maxwell, the court relied on cases that had defendants in prison for longer than the statutorily authorized.
So it doesn't matter because you're saying 9 months doesn't matter either because it's supervised release and not prison?
I am, Your Honor, and the reason for that is that
In some ways, supervised release is just as challenging sometimes as some prison settings, given all the conditions placed on a person on supervised release.
the district court retains authority to terminate a defendant's supervised release at any time. So based on the government's concession today, the defense could move for that relief before the district court. But for this court.
So it sounds like the government is saying that no amount of supervised release, even if in error, can substantially impact a defendant's rights for a plain error review.
Well, Your Honor, that is not my position, nor was that this court's holding in Maxwell.
Okay.
And
Well, but 9 months isn't sufficient?
Your Honor, in Maxwell, the court stated 11 months, but it found the length meaningful. At least 3 times in the opinion, the court said almost a year of additional unwarranted supervised release. And here, we don't have a defendant that was sentenced to a term in prison longer than was statutorily authorized. Here, the probation officer was advocating for a 24-month term of imprisonment, and the court imposed 19 months. So we have 1 month imposed on count 2 here.
I'm sorry, so this didn't come up at sentencing? I mean, the government just stood there and somebody got a longer supervised release sentence and is authorized by law, and the government's position is, we can't fix that? That just strikes me as so counterintuitive.
So
I mean, how'd this happen?
Well, you're speaking to the plain error analysis. The court needs to be put on notice.
I know, but sentences that exceed statutory maximums, I totally understand plain error and substantial rights, but I am somewhat surprised that the government's position is that a sentence that exceeds a statutory maximum might not affect somebody's substantial rights.
And Your Honor, if it were more than a month, our position might be different.
Well, apparently not if it's 9 months, but somewhere between 9 and 11, it sounds like the government's position might change.
And this court doesn't need to make that determination now, but if it were to reverse and remand based on that 1 month of supervised release, it is undermining the plain error analysis and eviscerating prongs 3 and 4 of.
There is a statute, I can't remember the section number, that says we're supposed to take sentences, combined sentences like that in the aggregate. Do you remember the statute I'm talking about? I didn't bring it with me here, and it's just, with respect, you said the court sentenced separately on counts 1 and 2. And you agreed that if it's in the aggregate, it would be 60 months supervised release less 19 months sentence equals 41 months excess. If we treated it in the aggregate, and I need to look at that statute, but I thought it said we're supposed to treat sentences in the aggregate when they're component sentences.
Your Honor, if
It might be section 3624E. The term of
Sounds right.
supervised release commences on the day the person is released from imprisonment and runs concurrently with any federal, state, or local term of
No,
probation or
there's another
supervised
one that
release.
says component sentences are to be treated in, it uses the word in the aggregate.
for active custodial time, Your Honor.
I think probably for all administrative purposes, I think.
Okay.
Yeah. Anyway, I gather your argument basically on the statutory issue is just it didn't affect the substantial rights.
That's correct, Your Honor. There are instances when multiple counts should be running concurrently, both the prison time and the supervised release, but that's when the district court is silent as to which counts it's imposing its sentence on. I would encourage this court to look at the Ninth Circuit's decision in Hertler. It's actually cited in the Actor case, and there the court explains the language of the statute for imposing supervised release speaks in the singular, term authorized by the offense and term. So we're talking about revocation, we're looking to the specific charge, not the underlying offenses generally. I would request the court affirm for the reasons stated in our brief.
All right. Thank you.
Thank you.
All right. Mr. Wellman, do you have anything further?
Very briefly, just in addressing this, the supervised release following the incarceration, and why I would argue that it is substantial is, the 59 or the 41, I'll leave it to your honors to determine as to aggregation, but if you look at count 1, where it was Judge Osteen reimposed for 36 months, when really it should have only been 17 months.
Well, that was a 17-month over a charge, and if you treat the sentences separately, as the government urges, then that error may not be subsumed in count 2. That may be an error with respect to count 1, and he's serving 17 months too much. The problem with that, of course, is his substantial rights may not be affected because the 17 months would be subsumed. He'd still be serving supervised release under count 2 for another 58 months or 59 months.
That's correct, Your Honor, but if there were a circumstance where he faced revocation, once that first term expires, he may still be on supervised release for count 2,
Right.
but he would only be facing revocation for count 2 rather than count 1 and count 2.
Yeah.
So even though the term itself is subsumed, it makes a difference whether you're being supervised for count 1 and count 2 at the same time.
And so that's why that also impacts his substantial rights.
Yes, Your Honor. So that was simply what I wanted to close up on. Thank you, Your Honor.
All right, thank you. We'll come down and greet counsel and proceed on to the next case. Mr. Wellman, you were court appointed, were you?
I was, Your Honor.
All right, I'd like to recognize your service, especially in view in the public, because this is so important that we have U.S. attorneys appointed formally that represent the government. And we always worried about taking care of the defendants on the same level, and court appointments of people of your caliber satisfy that very well. Thank you very much. We'll come down and greet counsel. United States versus Chen, and I guess Mr. Greenberg, whenever you come forward, and whenever you're ready, we'll hear from you.
Your Honor, I'm ready to proceed. May it please the court. My name is Kerry Greenberg on behalf of Mr. Chen. Your Honor, as you know, we're seeking in our brief that the court will reverse the convictions against Mr. Chen and dismiss the case. We have other issues we've raised as well, that in the event that that were not to occur, that certain pieces of it should be carved away. We have a forfeiture issue. We have issues about the jury instructions. If I could, I'd like to give the court just the briefest of backgrounds of the factual circumstances. As you know, this case involves the buying and selling of gift cards, and he was charged with access device fraud. The gift cards that Mr. Chen started buying and selling was he went onto the net. I know they call it the dark net, but he was on the net, and he bought things from a place called Tibao and from eBay, and he found that he could buy gift cards primarily from Walmart, but other places as well, at a discount. And then he could go and he could redeem those cards for face value, and then he could make money on it.
These are stolen cards?
The ones were determined to be stolen or through the course of fraud, yes. I mean, I don't know that all of them were. That wasn't actually something that was proven, but there was proven that there was some that were, so I think that that satisfied the first prong, I would suggest, of the argument, which is that they were obtained in a way that made them unauthorized. So the first thing is you have to obtain them.
Sort of a black market.
I don't know that it's a black market.
Well, if you're dealing in stolen cards, and some of those cards are stolen and it's sort of known, he buys those cards at risk, and the whole way he handled them thereafter with speed and was in order to cash in on the stolen cards before the issuers or the owners were able to forestall those transactions.
Your Honor, I'm going to just ask that you consider tweaking that just a little bit to the following. I think that the reason, because if it was in the, as you said, it was in a black market.
Can you just keep your voice up? Yeah.
Absolutely, sir. To the degree that it was in a black market, if he buys something, what happens, of course, is, you know, they take the gift card, they peel off the secret number and the PIN number, and they can send that and use that. You never actually need to have the receipt of the card. Now, if you are on a site, they could send that, they could sell that exact card number 4 or 5 times in a row, and it would be a race to whoever was going to be the one that gets it, because you're not getting it from a trusted seller. So one of the reasons to do it fast, quite frankly, would be just to make sure that you were the one that got the money that you just bought for the card. It's not necessarily because it has anything to do with the purchaser. Gift cards, generally speaking, are not actually owned by the owner of the gift card. They are, by definition, gift cards. So what happens is somebody buys the gift cards and then gives them away. You're never going to, normally, because they don't take a registration number, they don't take any personal identifiers. If I buy gift cards for my grandchildren or for my friends or for my employees and I give it to them.
Well, what's your point in this case? You're saying he didn't commit wire fraud?
Well, it wasn't wire fraud. He wasn't charged with that, Your Honor. And no,
Access device fraud.
he did not commit access device fraud for this reason. Because the way the Congress set it up is first you have to obtain it. And you obtain these cards, they become unauthorized if they were lost, stolen, they expired, or if they're obtained by fraud. And then when you obtain these, you have to then intend to defraud someone else. When he took the gift cards that he received, that he bought from a seller.
Wait,
he
I'm
was
sorry,
not-
can you just tell me where the someone else comes from? I
Well,
mean,
it's unclear. So what happened?
that seems like it's a problem for your argument.
Well, Your Honor, I would submit that it's not for this reason. If you go on to eBay, and you can today buy gift cards all day long that are discounts. I mean, they sell them, they're both legitimate and not. If you just buy and sell them, that's not a problem for him. If it turns out that they were unauthorized, that might be a problem for him for trafficking if he traffics and uses them with the intent to defraud. But the way they initially were obtained,
I thought you agreed in this case he was using some stolen cards.
I said that the evidence would support that, and I don't dispute that some of the cards were stolen
But-
and
but
therefore
your-
unauthorized.
But your argument, or as I understand it, is, yeah, he's using stolen cards. He steals things. He's a thief, but he's not a fraudster because he didn't intend to defraud, because he didn't interact with any victims.
No.
Something like that?
Well, no, if I could say.
Well, then, okay, I was trying to help you, maybe incorrect.
No.
Maybe I shouldn't try to help you.
No, please do help me. Judge Thacker, I can tell you're going to do a better
He
job
did
than
not
I am.
have an intent to defraud, is what I'm understanding
That's
your
correct.
argument to be.
That's correct.
So now, now maybe you could explain, perhaps better than I did, why he didn't have an intent to defraud under the statute with which he was charged.
There were hundreds of gift cards. The government found 3 or 4 people over a 2-year span that, unfortunately, in today's world, there's lots of fraud, and that these people were contacted by somebody, it was never known who, that made up stories and for various and sundry reasons got them to go down to Walmart.
And the government didn't charge him with doing that. It wasn't him that did that.
He
They
was
didn't
not-
charge him with that.
That's right, and there was no statement that he knew those people, or he was part of those people, or he was part of that fraud. So now the question is, he gets these unauthorized cards because perhaps they're stolen, but not from fraud necessarily. And then the question
If
is,
they're stolen, they're depriving the owner of the card of that money if they're stolen.
that's,
And
par-
he is taking those cards and cashing in on the money that the owner had, the unknown owners, the victims, and taking that money and using it for his own purposes.
but Your Honor, he's two levels down the road from that.
But
He's-
I don't,
And can I say this one thing? I'm sorry, Your Honor, I want to interrupt you, but, okay, yes.
Well,
yes,
but you
ma'am.
did interrupt her. You said you didn't want to, but you did. I think maybe you should let Judge Harris ask her question.
here's my
Absolutely.
question. It's about the difference between a conduct element and an intent element, because I do understand your argument that this guy was not sort of a frontline scammer. He was not telling the lies. He would not meet that conduct element, but I don't
correct.
understand why it's not enough. Just assume for a minute, I think a jury, based on the evidence presented, could find that he knew that these cards were obtained by fraud, that he rushed in to redeem the codes before they could be shut down. Why couldn't a jury find from that that he intended the result of his actions, which would be that the original owners were defrauded?
Because, Your Honor, if that were the case, then it would be superfluous to say obtain it with intent to defraud. What you could just simply, the answer would simply be that Congress would say that if you traffic and use unauthorized access devices, by definition, you're guilty. But they didn't. They asked for something else, and the activity, as you point out, the activity that's necessary, the verb of defrauding, it requires Mr. Chen to do some act that causes fraud.
He tried to launder, knowing we're assuming that he knew they were fraud, stolen, and he tried to launder them to ultimately convert them into clean cards or to obtain merchandise, and he got a slice of that. The whole scheme was to launder the fraudulent money obtained from the cardholders, and he very well knew that the only way to do that is to do it quickly before it was being uncovered. And he obtained the proceeds from the owner, knowing it was stolen money.
Judge Neumeyer.
Isn't that what happened, alleged?
No, Your Honor, because I think there are different statutes, right? There's money laundering, as you just indicated.
No.
There's
Access fraud. Access fraud.
Access fraud requires something significantly different. Access fraud requires that when he uses the card, he with the intent, he obtains it with the intent to defraud a third party. Your Honor, you know that they can be unauthorized access devices if you find them on the street, if they're lost, if they're stolen, if they're expired.
Those are hypotheticals. The case here is that a jury could find he knew this was stolen property, and he was trying to cash in on stolen property by manipulating the cash-in basis to obtain clean cards.
Your Honor, let me ask you this, let me just suggest this. If they were stolen, let's assume somebody goes and steals 10
Well,
cards.
don't you think there's sufficient evidence for a jury to conclude that?
Yes, I do.
Okay.
Yeah,
All
so-
of that, but your point is not the intent to defraud part.
Exactly. So exactly. So it could be either through fraud or just through stolen. If it's stolen, there is no fraud at all involved. It still is an unauthorized gift card. But then the question is, he has to take that gift card and then use it. He has to obtain it with the intent to defraud, and then he has to actually, as we know through fraud, he has to both deceive and cheat somebody afterward. Walmart, where he redeemed the
Oh, he
card.
cheats the original owner. He knows it's not his property, he knows it belongs to somebody else, and he tries to take it and convert it to his own property
But not-
in violation of the original owner's money.
But not through fraud, Your Honor. If it's just a
Fraud.
theft, you know what I'm saying to you is.
It's all deceitful. The whole intent was to take that money away.
Your Honor, the Congress used two different words. They said if you obtain it by fraud, the unauthorized card, or by theft. They distinguish
What do you
between.
think he intended this whole scheme was to do? The whole scheme had intent, was filled with intent. He had a very clever scheme as to have his runners go and cash it in quickly and give him the money and then buy clean cards, which he sold. And the question is, that was all done intentionally, and it was all done with the idea of depriving the original owners of their legitimate money.
Your Honor,
He did not participate in the original theft,
he did not.
but that doesn't save him.
It should, though. It should, because if they wanted to charge him with buying and selling stolen property, that would have been a different offense. It's not a question of whether the conduct could otherwise be illegal.
Whether he committed fraud with his access to
That's the question, Your Honor. Yes, that's the question. And the government, I would submit to the court, actually expanded the nature of the conspiracy inappropriately in order to try to find that. And they did it in two ways. Number one, they tried to link in these initial fraudulent purchases, if you will, or theft, but the people that testified. And they also wanted to link in Andrew Feldman, which was a one-off, I know I don't have much time now, that with regard to the credit card, the one credit card that had nothing to do with the gift cards, that wasn't part of any of the people that were involved in this in any way, shape, or form, but there was one standalone credit card that he ended up getting and tried to use for $600. And that happened after all the people that were in the conspiracy pled and were cooperating with the government. And they tried to expand the entire universe of that to his prejudice so they could try to bring in this other fraud that he was not part of. You know, as I said, it's not a question of whether you condone the conduct, and there might be other ways to prosecute him. This was the third or fourth superseding indictment. And the reason they had to keep trying to figure it out is because they weren't sure how to charge this. But I'm submitting to you that they got this wrong. That ultimately, they didn't prove what they need to prove. It's not enough to go back and say that because you used the card, that somehow he facilitated the initial fraud. That's not the case. And I think that matters. I know I have a little bit of time to rebut, but.
Okay, thank you.
Thank you.
All right, Mr. Ray.
Good morning, Your Honors. Zachary Ray for the United States, and may it please the court. I'll begin where my friend on the other side left off, which was the structure of the conspiracy. I think it's important for the court to understand just how this works. One, there was a source of unauthorized access devices. These were the stolen gift and debit cards that were stolen from the individual victims here. Second, there was a supplier of these unauthorized access devices. These were people like Trace.
And they, when you say they were stolen, that right at the very beginning, that's where the fraud was. They were stolen through deceit, correct?
That's correct, Your Honor.
And that's the 2 steps removed from appellant here. So we start there, and then what do they do with the gift cards they got through deceit?
Sure. So after the gift cards are obtained through deceit, someone like Tracy traffics those access devices in the form of profiles to people like Mr. Chin.
Right, so that's the second layer, also not not appellant here. And so did that second level of the scheme involve deceit or fraud?
It does involve fraud because it involves the transfer.
Because you're relating back to the first layer?
That's correct, Your Honor. It does involve fraud because what people like Tracy are doing is they are trafficking those already unauthorized access devices.
And to be clear, Tracy is not the appellant here. We still haven't gotten to what appellant has done that indicates any intent to defraud.
That's correct, Judge Thacker, and I'll get to that. So the testimony that the jury heard from Tracy, who was a supplier, was that he communicated with Mr. Chin, that he got Walmart accounts from hacking. Tracy testified that hacking means to get someone else's credentials without their authority. He said that he gets the accounts from the dark web. He said typically only illegal things are bought and sold on the dark web. And he goes so far as to say it had to have been illegal. This is testimony that the jury heard. It was clear from Tracy's testimony that Mr. Chin understood at the point that those accounts were transferred and sent and exchanged between Tracy and Mr. Chin that they were from unauthorized sources, that they were stolen from the true owners. The next step in the conspiracy was for Mr.
Right. Were there substantive access device charges separate from the conspiracy?
Yes, Judge.
Okay.
So count one.
And so your conspiracy, I think I understand where you're going with your conspiracy, that all of that, everything they all did together, and that testimony indicates that appellant was a part of that conspiracy. But what about the substantive standalone counts against appellant? What evidence, other than relating back to the conspiracy, is there that he intended to defraud?
Sure, Judge. So I'll begin with the fact that the appellant knew from the time that he received those gift cards that they were unauthorized and that they belonged to the other people. To the extent that the Judge, you are asking about whether there's sufficient evidence that the jury heard to convict of the access device fraud, there is, and here's why. We understand from the runners that Mr. Chin instructed them how and when to redeem these gift cards. Anyone that knows how gift cards work knows that the way that Mr. Chin instructed the runners to redeem the cards was not above board. This is what he told them to do. He said, go in and be very, very fast. We heard from runners, the jury heard from runners like Jin Hong. Jin Hong's job was to sit outside of Walmart stores and wait for Mr. Chin to send him a gift card redemption code and a PIN. Immediately after that, Jin Hong went into the Walmart because he knew that if he waited too long, the value of that card would disappear. Mr. Hong testified that often the value did disappear, and those were in cases where either someone else purchased the card or the true owner realized that there was a fraud and got their money back.
So if I could make sure I understand what you're saying in response to what evidence there is that he knew what evidence there is that he had an intent to defraud. It is, first of all, the testimony of Mr. Tracy that he told appellant all of what had happened before in steps 1 and 2, and that they were obtained by fraud. And then based on that, because of the way that then appellant conducted his criminal activity in terms of do this quickly, all of that stuff, the jury could infer that he had an intent to defraud, or that there was an intent to defraud?
I think that's close to what I'm saying. Maybe I can put a finer point on it. So for intent to defraud, the government had to prove that Mr. Chin acted with a purpose to deceive and cheat. I think the government proved that.
And I'll have the cheat, well, go ahead.
I think the government proved that Mr. Chin had the purpose to deceive and cheat with respect to trafficking access devices and using access devices.
I would think when he goes in at a very quick pace into the Walmart, knowing it's stolen, and trying to get money from Walmart based on stolen, he's attempting to defraud Walmart. Walmart, if it knew the facts, would not have given him that money.
I think that's right, Judge Niemeyer.
And so not only is there the initial fraud from the owner of the gift card, which he didn't participate in but knew about, He then took the card and quickly presented it to Walmart, knowing that if he waited longer, he wouldn't get the money, and Walmart wouldn't give it to him. So he was deceiving Walmart by that manipulation.
That's correct, Judge Niemeyer. And even if we go a step further, the jury heard information from some of the runners that Mr. Chin instructed them to take it to go a step further, which was to actually lie to Walmart if one of the cashiers or one of the customer service representatives came up to them. And that was to say that they bought the cards from some.
And which testimony do I look to for that?
Your Honor, I believe it is Jin Hung and Mulan Wu. I believe both of them told the jury that if and when they were caught, Mr. Chin told them to lie to deceive Walmart about the purpose of their transactions and about the origins of the cards. I think that also shows an intent to deceive and cheat. With respect to use, I think it's a bit more clear. And I think the example from Andrea Feldman is probably the easiest one for most people to wrap their heads around. So with respect to Andrea Feldman, Mr. Chin asked for her debit card information explicitly because he wanted to buy goods that were outside of the Walmart universe. When he did that, he both lied and cheated. He lied to Costco, impersonating Andrea Feldman, in order to deceive and cheat Andrea Feldman out of her own money. So in that sense, we have proven
Well, that was the aggravated identity theft too, wasn't it?
that is the aggravated identity theft, Judge, but it also goes to the access
Goes to
device.
fraud too.
Yes, Judge.
What evidence is there that he used any of the money that was wired to him to continue funding the gift card scheme based on the 2 dates charged in the indictment?
Sure, Judge. I'll start with the rule here, which is evidence that a defendant was engaged in, I'll start with what's been said in the Stewart case in 2001. Evidence that a defendant engaged in drug trafficking, here it's access device trafficking, and had insufficient legitimate income to produce the money used in a transaction is sufficient to establish that
But
the
that's
money.
like, that's a test, if the government can't show, the government doesn't have to actually show what happened to the money.
Sure.
And can instead rely on that as circumstantial evidence. But in
Yes.
this case, the government, for whatever reason, did come in and show what happened to the money, and the answer is the money stayed in his bank account. So I don't see how, when you have direct evidence that the money stayed in his bank account or was used for normal life expenses, you can turn around and then say, well, forget the direct evidence, we'd like you to rely on this inference that we use when there is no direct evidence.
I think, Judge Harris, there are two issues with that view. I think one of the assumptions that's being made is that the government had access to all of Mr. Chin's bank accounts and all of his finances, and I don't know that to be the case.
Well, I don't
Well, what we
understand-
know is the government had the burden of proof, and I didn't still hear an answer to my question, which is, what was the evidence at trial that appellant continued funding the gift card scheme with the money that was wired to him based on the 2 dates charged in the indictment?
Sure. Special Agent Jang testified that the defendant, between the years of 2015 and 2021, had only $90,000 in legitimate income. So we start there.
No, so
No,
that
start
tells me
with the
that,
indictment.
as you said, there must be some other, like, maybe there are some other bank accounts where he's getting this money from China and plowing it back in. But we know what happened to the money charged in count 6 and count 7. We know from the bank records that the government introduced, that money did not go back into the scheme. I don't know how you get around the fact that, like, I'm looking at my reproduction, and it just says where the money went. And the answer is it stayed in the account, or it went to a debit card purchase, or to Costco, or monthly bills.
Here's what we know, Judge. Again, I'll reemphasize that we know that there was not sufficient income in the account.
Right, that's why I think your conspiracy money laundering charge is probably fine, because probably you can rely on that inference as to sort of the money writ large. But these 2 counts are about very specific amounts of money that were received on very specific days. And as to those 2 amounts of money, if I am looking at this account activity following transfer evidence, how could a reasonable jury looking at that say, no, actually, this money went somewhere else?
Here's what we know from some of the runners about how they were paid. Again, we start from the position that there was that there was insufficient income in the account to begin with. We also know from runners like Jin Hung that they received a percentage of the money that they redeemed. So this is 3 to 5% of how much money they were redeeming at the Walmarts. We know that in particular, Jin Hung redeemed over $1.1 million. And that he stayed at Walmart and his payment was essentially to keep him there. That money had to come from somewhere. On these facts, I think a reasonable juror could conclude that the money from the scheme went to pay runners just like Jin Hung.
Yes, the money from the scheme, but not the money from the $68,000 transfer that was received on March 3rd, and not the money from the $17,000 transfer that was received on January 29th, because we know where that money went, and the answer is it did not go to the runners. I don't want to harangue you. I'm just not hearing how I get around as to those two specific transfers. We know where the money went.
I think the disconnect, Judge Harris, is I think I'm making an inference, and I think a jury could make an inference, that the money had to recycle, even in those two transactions. And I think you're looking at the one, Your Honor is looking at the one bank account and seeing a lack of movement, and that is concerning to the judge. But I think based on the sufficiency test, I think there's an inference that the jury could make.
Just because you think like the jury could infer that after it went into a parking meter, it like somehow left the parking meter and went to the runner? Like this particular fund, or?
No, Judge, but again, I'll remind the court, the court that line-by-line tracing is not required.
Well, I know, but once you offer it up, that doesn't, I'm sorry, I don't want to take up all your time.
No, I understand the court's concern. I don't know, I'm not aware of a Fourth Circuit case that requires that level of line-by-line tracing. I'm also not aware of a Fourth Circuit case that penalizes the government for producing it in situations where there is a reasonable inference that the jury can make.
Well, the inference would be drawn from the modus operandi that was generally applicable to all transactions.
That's correct, Judge Niemeyer. With my remaining time, I will address briefly the jury instructions. My friend on the other side complains of 3 different jury instructions. What he fails to do is accept that the invited error doctrine bars the review of all of those jury instructions. Mr. Chin seems to concede that all of the jury instructions in this case were jointly proposed by both the government and Mr. Chin's trial attorney. What he recognizing that invited error is a high bar, Mr. Chin tries to skirt the issue altogether. He first tries to argue that there should be some type of exception to the invited error doctrine. That is wrong. The only Fourth Circuit case that I could find from Mr. Chin's brief in which the Fourth Circuit created or recognized an exception to the invited error doctrine is a 2025 case, United States versus Nam, NAUM. In that case, the Fourth Circuit recognized and declined to apply the invited error doctrine because there was an intervening change in the law while that case was on appeal. That intervening change in the law was the Ruan case, and it was a doctor kickback case. Here, those facts just simply aren't met. The Dubin decision here was decided 3 months before the trial. Therefore, there's no reason to decline the invited error doctrine. The next thing Mr. Chin does is also unsuccessful. He tries to cite out-of-circuit precedent, which is simply incompatible with the Fourth Circuit's jurisprudence for invited error. For example, Mr. Chin relies on a Ninth Circuit case, United States versus Perez, to suggest that this court should proceed to plain error review on the jury instructions instead of invited error.
Can I ask you, just on this Dubin point, you're sort of arguing that we should not apply Dubin. But I would have thought that even if we did apply Dubin, your argument would be that the fraud is the crux of the offense, that when he takes AF's information and tries to use it to buy tires, that is the crux of the offense, and that you wouldn't have a problem even under Dubin? Or are you arguing Dubin doesn't apply and good thing, because we could not defend this conviction under Dubin?
Sure, Judge, I'll clarify. What I'm arguing is there's sort of two species of Dubin arguments I think Mr. Chin makes. One is with the jury instructions. On the jury instruction issue, my argument is that the court need not even look at that. On the sufficiency of the evidence for whether or not aggravated identity theft is at the crux of the predicate felony, the evidence that the jury heard is sufficient to sustain that conviction. So to Your Honor's question, I'm not...
But they are related. If you're right about the invited error, then the only question we would ask is whether a jury could have found the aggravated identity theft as the jury was charged, and it wasn't charged that it has to be the crux, so we wouldn't even ask that question.
That's right. I'm sorry if I'm misunderstanding.
Doesn't matter. Can I ask you a question about the forfeiture order?
Yes, Your Honor.
So when the sentence is pronounced in September at the sentencing hearing, and he's sentenced to 84 months in prison, there's no forfeiture order, and the amount of the forfeiture hasn't been set. So the sentencing is over, but he doesn't know what his sentence is, at least the full extent of it. That does seem sort of problematic. Can you tell, was Mr. Chen there at the second hearing when the district court sort of finalizes his sentence and says how much he has to forfeit?
Off the top of my head, I actually don't know if Mr. Chin was present for the second forfeiture hearing.
The defendant's supposed to be there when he's sentenced, right?
That's correct, Your Honor. Here's what I think the district court thought it was doing and did. What the district court did tell Mr. Chin at sentencing is that it was intentionally keeping that judgment open. And by doing that, the district court put Mr. Chin on notice that there was an additional part of his sentence that was still to be determined, and that was the forfeiture order. So regardless of if Mr. Chin was present or not for that second forfeiture hearing, it's clear that at sentencing, when we know Mr. Chin was present, he was put on notice by the judge that there was an additional forfeiture issue coming down the pipeline. I think what the district court is doing is trying to abide by the spirit of Rule 32.2, even if not technically the letter. And based on this court's precedent in cases like Martin, what the district court did is not erroneous. This case is actually stronger than the case of Martin, the Fourth Circuit's case in Martin. In that case, the forfeiture order came after the judgment. In this case, the forfeiture order came on the exact day of the judgment. And it seemed like Mr. Chin actually benefited from that additional time that the court had to consider the forfeiture issue, because the judge credited many of Mr. Chin's arguments, which reduced that forfeiture amount from what the government originally requested in this preliminary order of forfeiture.
And since this, I think this is a harmlessness review, and not only was it harmless, you're saying he actually benefited from the out-of-order sequence.
That's correct, Your Honor. Harmless error review attaches here, and that's correct. I think Mr. Chin absolutely benefited to the tune of about $200,000 from the fact that the district judge here took additional time to consider the arguments, and in doing so, he rejected some of the government's calculations and credited some of Mr. Chin's calculations instead.
Good.
I see that my time is almost up. Unless the court has other questions, I will thank the
All
court for
right,
its time.
thank you, Mr. Ray. Mr. Greenberg?
3 points. I could hit the high notes on this one. The first one is the Dubin issue. Your Honor, I'd like you to consider the fact that the crux of the gift card scheme, there was no identities of any of the gift cards. There was no identity being sought at any one time for any of the hundreds of cards.
But what about the debit, what about the debit card?
No, the
which was
one
also
debit
part-
card clearly was, but
Okay.
okay, all right. But my argument is that that's out of sync with anything else that was going on, that the one transaction was outside the conspiracy. The people that were involved, Tracy was not part of the conspiracy of the gift cards. He never sold them, redeemed them, or any part of the buying or selling of them. That was a one-off, and that that the jury should have known that the crux was not to get other people's identities. And that's the very thing that the Dubin court looked at, where somebody was getting identities, but they weren't using it to commit the Medicare fraud. And they said that the identities were not part of the scheme, and therefore that the enhancement should not have been applied because it's a significant enhancement. The same exact thing is happening here. He's getting 24 months because he tried to buy $600 worth of tires using someone else's identity, clearly. So the problem is that's not a federal offense if it's in its own category by itself because it doesn't meet the 1,000 threshold. And this jury wasn't given the proper instruction, and the court does say, this particular court has indicated there could be an exception, and it seems to me if both the government and the defendant thought that this was the proper law and they sent it in, and neither the court nor either the parties understood that 90 days before this, the Supreme Court changed how you instruct a jury, that would be a very good reason for this court to find an exception in this case. This is the zebra outside of the horses. It's different. And I think I submit to the court that this is a reason to consider it. The other issue is, in the forfeiture proceeding, it is my understanding in this particular case that the judge never entered the forfeiture order, as he's required to under 32. He never indicated he was going to give a forfeiture, as you've made exceptions before, this court has, over the idea that someone said, I'm going to give forfeiture, I'm telling you it's going to happen, and the court didn't do it timely, but this court found that he was put on proper notice. Here, Judge Austin never said to Mr. Chen, I'm going to enter a forfeiture order. In fact, he found that the calculations by the government was not appropriate, and he proceeded to sentencing. He gave him 84 months. He gave him 3 years of supervised release. He talked about restitution, and then he said to him, I want you to sign something showing you're on notice about your appeal, and I'm now remanding you to the custody of the marshal. And as he stood up to leave, the government stood up and said, Your Honor, wait, but we'd like to still brief this whole issue of forfeiture. And he said, oh, okay, you can do that. Now, he has announced sentence in a public setting. And from what I've seen in another case I was involved in, that once that happens, the district court is no longer able, no longer has the authority.
The Supreme Court says that's a procedural timing order, and when we're going to look at it, we really need to look at the substance of the whole forfeiture business to make sure he has notice and ability to respond. And in other words, it's not a jurisdictional issue. It's a procedural timing sequence that's imposed and was violated here.
Your Honor, but there are two issues here. There's both the failure to follow Rule 32, and there's the fact that they announced publicly the sentence, and he's trying to now open up the sentencing when it's too late. I've had that in a district court, in this very district court, where a judge sentenced my client to a particular set of time. He reconsidered the sentence within 3 hours, and this court found that that was not allowed, that once he announced sentence, that ended the sentencing transaction, and this court had sentenced Mr. Chen to his time in jail and had sent him off to the marshal, and then decided they were going to open it up. And even then, the judge didn't say, and by the way, I plan to order some forfeiture, because the judge had yet to hear something that he was convinced that they had calculated properly, that he should have to order the forfeiture. So it's not just the 32 section, Your Honor, that you were just mentioning, but it's also the fact of the announcing sentence and whether he's lost jurisdiction at that point to continue forward. The last point I want to say is that, Your Honor, Judge Thacker, the Walmart has, you can check out these gift cards at a standalone. You don't have to talk to the Walmart employees. They don't mind how many people, they make a lot of money out of people buying and selling gift cards. So you don't have to deceive, there is no deception, because Walmart doesn't stop anybody. They don't ask questions. It's gift cards like finding money in the street to some degree. They don't actually belong to anyone as far as you would know. And when you hand it to Walmart, they don't ask, you don't have to even hand it to Walmart. You go to the machine, you put in the number, and it spits out your credit. So he certainly didn't deceive Walmart members, and he certainly didn't deceive and cheat them. Walmart never lost a dime. So maybe they could do a lot more to stop this gift card stuff, but quite frankly.
If Walmart knew what he was doing when he did it, they would have never provided him with the money. In other words, he was trying to cheat around the system by going quickly and taking advantage of that machine before Walmart could discover it. That was the fraud on Walmart.
Your Honor, Walmart didn't testify to that fact.
No, that's the facts of the case. It's not a question of whether Walmart testified. It's a question of they got that money out of a machine that they weren't entitled to because they were deceiving the system. And they had lies planned, and they had excuses planned. The timing was planned and very closely calculated. And all of that was in an effort to get the money that they knew was stolen. Now that, to me, is a fraud on the bank, on that little machine that was issuing the money.
Your Honor, I see my time has expired, and so.
Yeah, okay. You can respond if you wish.
Well, Your Honor, I realize, Judge Niemeyer, I realize that you're not a fan of this particular argument, and I submit to you that Walmart doesn't do anything to stop people from taking gift cards, in particular gift cards, which really is like finding money in the street. If I leave this courthouse right now and I find a Starbucks card at the bottom that someone bought years ago, if I want to, I can hand it to Starbucks, and they'd be happy to give me,
Yeah,
if there's
Walmart
$5
also
left, they'll give me a
puts-
cup of coffee.
Walmart also puts plants and goods outside the door there for sale, assuming you'll take them in and pay for them. But people do come and take them away. And it seems to me, when they come and take them away, they're defrauding Walmart of those plants.
Yeah, but Walmart, if they really wanted to stop this, they'd have a lot of ways of doing so. So I'm not disparaging them and trying to say they're trying to foster fraud of any kind,
They're
but
not
or
fostering,
theft. But
they're
the
not
bottom-
fostering, they are being deceived by Mr. Chen and his program. His program was to lie, to provide an excuse, to do it timely, to do it very quickly, to do it at a machine as opposed to the cash register.
They lose no money, Your Honor. They don't lose a dime, not one solitary
It
dime.
doesn't matter that it was, Walmart would not have given them that money.
Well, you know, I submit that speculation because I understand the moral structure.
So you're suggesting that you walk up to Walmart and say, I have a stolen credit card, will you give me the cash?
No,
Register would have given her?
I submit that if I walk up to the cash register and I pull out my gift card and I say, I want to buy this off my gift card, they say, thank you very much. They ring up the sale and let me walk out the door. They don't ask me any questions. They're not trying to worry if they're being deceived or not. They just want to know if the gift card is valid and has cash on it. If it has cash on it, they let me go through with the transaction. I walk out the door. And if I don't want to do it with a live person, I can walk over to one of the little kiosks and I can put my gift card in and say, I'd like to have an Apple gift card instead of this Walmart gift card, and says, thank you very much. Thanks for doing business with us. And they send me out the door.
All right, thank you.
Thank you, Your Honor.
We'll come down and greet counsel and proceed on to the last case. All right, the next case we'll hear, United States versus Hicks. And I guess, Ms. Skelton, we'll hear from you first whenever you're ready.
Morning, Your Honors. May it please the Court. My name is Megan Skelton, and I'm here this morning on behalf of Mary Ann Mendoza. There are 4 assignments of error in my brief, and Your Honors, I would like to focus on number 3, and if I have time, move on to number 4, and I will submit on the first 2 unless the Court has questions regarding those. Rule 43 mandates that a defendant be physically present at sentencing. But in this case, the district court heard live victim allocution and announced that it would use that
You know,
testimony.
I found that argument curious because you've recast what really happened. The testimony that was used during Mr. Hicks' sentencing, right?
It was.
Testimony from something else. It was not her sentencing.
It was adduced at Mr. Hicks'
Okay.
sentencing.
Let me just finish, please. It was adduced at Mr. Hicks' sentencing, which was not her sentencing. She had a sentencing, and the transcript was brought into that sentencing, which is a form of hearsay. So the argument has to be that they couldn't have used hearsay, or you had some kind of confrontation right during sentencing. But there's no issue that she was not present during sentencing. She was present during her entire sentencing. The transcript was brought from some other sentencing, which was not her sentencing. To recharacterize that other sentencing as part of her sentencing that she wasn't at is just not a fair way to do it. The right way to do it is, can they use that transcript during the course of her sentencing? And I think that raises a lot of different issues.
Your Honor, respectfully, I disagree with
Okay.
the characterization. Your factual recitation is, of course, what happened. Mr. Hicks had his
Right.
sentencing.
And she was at her sentencing. That part you agree with?
I do agree she was at her
But you're
sentencing.
arguing she wasn't.
So my argument is that when the prosecution asked if it could use the live victim allocution against both Mr. Hicks and Ms. Mendoza, that essentially that became a portion of her sentencing hearing. Not the whole thing. That wasn't, there was a
Not
hearing.
even a portion of it. That was Hicks' sentence. It wasn't even a question mark. She was not entitled to be at Hicks' sentencing, and she was at her own sentencing, and she was never deprived at any part of her own sentencing to be present. The problem you have is they used that transcript in her sentencing.
So, Your Honor,
And
there's.
that's why Judge Niemeyer's recitation of your argument is the better one. The question is whether the use of arguably hearsay testimony at her sentencing without her having an opportunity to confront that witness was appropriate. I understand the
I think
argument
that's
that
exactly
Judge
the issue.
Niemeyer
That's
made.
exactly the issue.
So, Your Honor, I think there's a big difference between the transcript and hearsay and a live victim
It
allocution.
is hearsay, wasn't it?
Oh, it was
I
hearsay.
mean, the person wasn't in the courtroom.
It was hearsay, but the
And
real
is hearsay allowed at sentencing?
hearsay is allowed at sentencing.
That's why you're struggling with this.
Well, except that the problem is that a victim's allocution is not like regular evidence. It is emotional. It is in the moment. It is different from the written victim statement that they could have used, which would, of course, also be hearsay. In this case, the judge heard and responded to something physical, emotional, and visceral in deciding what.
You know, every sentencing, the parish priest comes in and talks about how this defendant was an altar boy, and how all the acolytes liked him, and how he was praised, and how he's fallen off the deep end. It's all emotional. We hear all that. We hear the school teachers talking about the defendants. We hear sisters sending in letters. They're not in the courtroom. In other words, there's a broad exploration about the person and the background to give the sentencing judge a better picture of what's for exercise of discretion. And so I'm not sure the fact it's emotional adds a thing. I mean, maybe you could attack it on hearsay, but I'm not sure where that takes you.
Well, the live victim allocution is simply different from the letter from the sister and the transcript.
Well, that's why it was used. It was used basically to inform the sentencing.
Absolutely, Your Honor, and I think maybe on that point we do agree. And there was a victim who came to Ms. Mendoza's sentence live and testified, and it's very powerful. The trial judge had responded to that evidence and absorbed it, and the allocution had done its job before the transcript was even produced.
Yeah, counsel, I thought on this one, Ms. Mendoza's lawyer expressly agreed to this whole thing.
He had no authority to do so. To be present
Oh,
when.
so this is why you have to argue she wasn't present at her sentencing. If I assume, why don't we just assume for a second, I think she was present at her sentencing. If that is the case, then this issue is completely waived, right? Because counsel 100% expressly agreed to the entire procedure.
I would say it is not expressly waived because it was something that was a personal right of her
Right.
own.
Again, I just want you to sort of hypothetically, let's assume she was present at her sentencing. Her lawyer would have been authorized to consent to this procedure.
If
that
she-
is so, then it was consented to and the issue is waived, right?
Hearsay is something that an attorney could consent to, that kind of evidentiary objection. But of course, our position is that this was an autonomous right that is not a confrontation right, that she was not there when critical information.
That's so unconnected to reality. She had one sentencing hearing. She was there at the sentencing hearing, and you're objecting to the use of a transcript from some other sentencing hearing at your sentencing hearing. And that's the facts of the case, and I don't know why you keep transforming she wasn't present. She was present during every minute of her sentencing hearing.
Your Honor, I understand the court has some concerns about this argument.
It's not a concern. I don't see where you're making your argument. It seems to me at some point you have to recognize that she was never intended to be at the other sentencing. She was denied, she was at her own sentencing hearing, and they brought a portion of the other sentencing hearing to hers. And the attorney agreed, her attorney agreed to that. She's there, and they're all in court. Now, you can argue that that shouldn't have happened, or it's hearsay, or he shouldn't have waived it, or whatever, but to argue that she wasn't present at her sentencing, it's like, it's like Alice in Wonderland, if we want to get. We just got to take the facts the way they are and then go from there.
I see my time is up. Thank you, Your Honor.
Go ahead. Did you have something else you wanted to make? I can give you another minute. I used a little bit of your time here at the end.
I appreciate that, Your Honor. I would like to briefly address the fact that the sentence was procedurally unreasonable as well.
All right, why don't you take a minute on that?
Ms. Mendoza was sentenced to an above-guideline sentence. The trial judge identified certain factors that that he explained were the basis for it. The loss amount, the number of victims, the nature of the victims, that they were vulnerable human beings instead of corporations or the government. Ironically, that it happened face-to-face instead of over the internet. In fact, what happened here is the judge double-counted factors that were already included into B1.1. B1 includes the loss amount. B2 includes the number of victims. B16 includes the nature of the victims, the fact that they were vulnerable people. So none of those factors were present to an unusual or extraordinary degree that took it outside the heartland. So no upward departure was appropriate in this case.
Okay, thank you very much. All right, Mr. Burnham, we'll hear from you.
Good morning, Your Honors. May it please the court, Charles Burnham on behalf of appellant Willie Lamont Hicks. There are two closely related issues before the court this morning in Mr. Hicks' appeal. One is, did the district court judge err by not raising Mr. Hicks' competency and ordering a competency evaluation? And two, did the district judge compound that error by then allowing Mr. Hicks to represent himself at trial? Before proceeding to the merits of those two issues, and I'll focus mostly on the first because that kind of resolves the second in large part as well, I'll comment briefly on the standard of review because this was given a fair amount of attention in the briefs. To summarize our positions, we think this court's decision in United States versus Bernard was incorrectly decided. With all due respect to the distinguished author of that decision, we agree with the dissent by Chief Judge Diaz. However, even working entirely within the frame of Bernard, particularly as interpreted some years later by this court in United States versus Ziegler, we continue to contend that plain error is not the proper standard of review, that the proper standard is abuse of discretion because Mr. Hicks was not represented by counsel during his ultimate Ferretta hearing. He was already going pro se during that hearing.
Can I ask you about that? And this is where I know you say your two claims like very much overlap, but I'm sort of struggling with whether they are separate in this regard, because before the Ferretta hearing, your client was represented by counsel for about a year, right? And so as to his competence, at least, maybe not to represent himself, but more generally, competency, why couldn't the issue have been raised then, when he was represented by counsel?
I wasn't present at those hearings, that wasn't me. Theoretically, it could have been, but I don't think that settles the question, because as even the Bernard opinion itself recognizes, competency has a temporal element to it, where it can change over time. And
Yeah,
that's,
but it seems like the argument, I do understand that, but it does seem as though here, the argument that is being advanced for why your client was not competent really isn't something that changes over time. I mean, there's no allegation that, for instance, there was sort of a mental disorder that grew more pronounced over time. It's just that he has these unusual beliefs about being a Moorish citizen, and that seems to have been stable over time.
well, we don't know that, Your Honor. There's no evidence in the record about that, and particularly when you have someone who is detained pretrial, the effect of pretrial incarceration tends to exacerbate any mental health condition, including, as in this case, delusional beliefs. The two prior
Let
hearings.
me ask you something. If the Ferretta hearing was lengthy, it's almost 2 hours, I think, or whatever. It was a lengthy hearing. And the court, I didn't count them, but the court kept telling him, you're making a bad judgment. You've got to have counsel. You got to do this. He said he understood. You're going to get 20 years. I know you don't. You're not as informed. A lawyer will help you. I know. Went through all of that just again and again, totally pushing that. And he insisted that he wanted to represent himself. What if the court had insisted, had said, okay, I think your ideas are pretty kooky. What you're explaining about these things doesn't make much sense to me, and therefore I don't think you're going to be competent to represent yourself. I'm going to appoint an attorney for you. And then if it's characteristic of what he showed there and what he showed with his prior counsel, he wouldn't cooperate with his attorney. He probably wouldn't talk to him. He'd probably undermine him and torpedo him, and would be up here again saying he didn't get his Ferretta right. The judge was in a tough spot on this case, and the judge recognized that the district judge, he spent a lot of time on this. He was asked a lot of questions, explored all these ideas. Some of these sovereign citizen ideas really did sound quite quirky and kooky, so to speak. And you quoted those in your brief, but there's a lot of other dialogue. I read his cross-examinations of witnesses. His main thesis was whether somebody signed a power of attorney and authorized the conduct. And I mean, he didn't represent himself to the level of an attorney, obviously, but the question, that isn't the question. And I just wonder where this goes if you're right on this.
Well, recall, Your Honor, that we're raising a procedural competency claim, so it's not my burden at this stage before this court to show that Mr. Hicks was in fact incompetent. The only question I'm posing is, was there reasonable cause which would trigger a duty on behalf of the judge to at least investigate the question
Well,
of
the judge was recognized he had these ideas, and we see them a lot in this court. The citizen sovereign allegations lack a lot of logic, and frankly, they sound sort of kooky. But the dialogue went on, and they exchanged ideas. There's no lack of understanding between the two. A lot of questioning, a lot of answers. I agree with you that when your client when Mr. Hicks spoke at length about his ideas, they didn't hold together. I mean, it didn't make much sense. But I'm not sure that was indicative of incompetence as much as a decision ideological decision that he had made for himself.
Well, Your Honor,
But my whole point is, at the end of, I read the whole transcript, at the end of the transcript, I'm sitting there, okay, what if it went the other way and the court ordered counsel? What would we be facing? You'd be standing here and you would probably be arguing he had a Faretta right. He probably butchered it with counsel. Counsel had a difficulty working with him because he wouldn't talk and with him in his anger, maybe even undermine it. We would have had the same type of difficult question, wouldn't we?
I'm not sure, Your Honor, and in this respect, I've somewhat come around to somewhat of the government's view that Indiana versus Edwards from the Supreme Court gives the district judges a certain amount of cover in so-called gray area cases, which perhaps this was, to appoint counsel, and then that's very unlikely to be reversed by
Well,
this
he
court.
had backup counsel, didn't he? And he consulted backup.
I mean, real
counsel.
counsel.
Yeah, I know, but the idea that even during, in the transcript, he regularly consulted counsel and spoke with them. We don't know what they said, but he initiated the conversation with counsel and spoke with counsel.
Yes, Your Honor. Can I just have maybe 45 more seconds to address?
Actually, that was you, right?
Oh, that was me. Yes, Your Honor.
I'm sorry, I didn't want to speak of you in the third person, but he worked with you, that's right.
And he did
Yeah,
consult with
yeah,
me
yeah.
extensively. Can I take maybe 45 seconds to
Yes,
address
sir.
the sovereign citizen points? I think
Yes.
that's very important. There's a lot of cases in this court and in the lower courts about sovereign citizens, flesh and blood, the Morris Nation, and in 90% of them, there's a finding by the district judge that the defendant was being obstructive. A lot of times they come up with these beliefs halfway through the case because someone told them about him in the jail, and they're disrespecting the court, trying to just throw sand in the gears. This case is very much not that. Mr. Hicks was very respectful. The report we had, which was submitted at sentencing, found that his beliefs were inextricably intertwined with his mental illness. Because recall that folks that have mental illness, like Mr. Hicks, sometimes glom on to extreme ideologies, aliens, conspiracy theories, extreme political ideologies, and I very much contend that the record here doesn't show your classic sovereign citizen. It shows a profoundly mentally ill man whose fragments of fringe beliefs he picked up along the way were inextricably intertwined with his mental illness that did call his competency into question. And what we're left with, the spooky thing about this case,
But nothing during the Faretta hearing or before or after anybody suggested that we're talking about mental illness. We were talking about crazy ideas, and the court had no difficulty in communicating with the man. I mean, every question was answered, as you say, respectfully and directly, and he explained how he understood this. The judge many times talked to him, you're facing up to 20 years and this type of thing. And, well, I understand what you're saying, though. It's not a frivolous argument.
I appreciate that, Your Honor.
Yes, sir.
Thank you.
All right, we'll hear from Ms. Muniz, I guess.
Good morning, Your Honors, and may it please the Court. MJ Kirsch Munoz here on behalf of the United States. Unless Your Honors have a preference otherwise, I'd like to jump right in and pick up where Judge Niemeyer left off with my colleague on Mr. Hicks's competency-related challenges. And I'd specifically like to start by stressing that the standard of review truly does not matter here. The Court need not resolve it. Even on abuse of discretion review, Mr. Hicks cannot show error in the district court's conduct here. And that's true for almost countless reasons, but taking my cue from how this court typically reviews procedural incompetence claims, there are three buckets of evidence relevant to this inquiry. Number one, a defendant's history of irrational behavior. Number two, his demeanor in court. And number three, prior medical opinions. And all three of these buckets show why the district court had no reasonable cause to order a competency hearing that no one asked for, and where his competency had already been determined at the September 6th Faretta hearing. The court there, of course, found that Mr. Hicks was competent to represent himself. We know that the standard for competency to represent yourself and to stand trial is exactly the same. And so, there was really no basis for the district court to revisit that competency finding at any point thereafter. So I'll start by discussing, the defendant's, Mr. Hicks' history of irrational behavior. There is none. In fact, the sophisticated scheme defrauding, ordinary, often vulnerable people out of millions of their hard-earned dollars, it was a sophisticated scheme. It showed Mr. Hicks' ability to manipulate. The scheme involved numerous corporate entities, aliases, bank accounts, email accounts, as well as elaborate training sessions to convince potential investors. And obviously, Mr. Hicks was an organizer of that scheme. He held control over several of the bank accounts. He directed the activities of his quote-unquote disciples, and he occasionally transacted with victims without Ms. Mendoza's assistance. And so, that is relevant. I believe that Mr. Hicks, claims that that sort of behavior isn't relevant to the competency analysis because it does have this temporal aspect, but as Judge Niermeyer pointed out, there is no indication that there was a mental disorder that, devolved over time such that he was not competent between when he perpetrated this fraud and when he stood trial. Now, of course, Mr. Hicks' demeanor in court was respectful, attentive, cooperative. He followed courtroom rules and procedures.
He said a lot of funny things.
He sure did.
And when I say funny, I'm being soft. They were quite kooky.
Yes, Your Honor, I agree. I think at various points he said what Judge Easterbrook has called wacky references to the sovereign citizen ideology. But Your Honor, I don't believe that sort of adherence to this ideology in fact gives rise to a bona fide doubt as to his competency. And that's, of course, what we're being asked to consider here. And of course, as Your Honors have also noticed, he acquitted himself decently well, actually. Certainly not to the level of a trained attorney. That is not the standard. But he pursued a good faith defense at trial. I didn't knowingly defraud anyone. And oh, by the way, as a factual matter, this wasn't a fraud. It would have worked if my clients had only followed through, if they had only done exactly, what I had told them. And one of these defenses is obviously more viable than the other, but you certainly can't say that Mr. Hicks didn't have a strategy. And the trial record is littered with cross-examination questions, to say nothing of Mr. Hicks's own testimony and his closing argument that pursue these strategies. Your Honors, there is simply nothing in the record to suggest a bona fide doubt as to his competence to stand trial. And, as Mr. Burnham has agreed, that question resolves, I think, in large part, the Feretta claim of error. Mr. Hicks, having been found competent to represent himself and to stand trial, the only concerns we have with the Feretta inquiry at that point is whether it was knowing, intelligent, voluntary, and unequivocal. And I think, the record very much bears out that it was.
Feretta is a strange bird. We have a constitutional right to have counsel, and then we have a constitutional right not to have counsel. And it raises, we've had those issues from time to time. It's not an easy line to draw.
Completely agreed, Judge Niemeyer. And you're right, that the district court walks a bit of a tightrope when it evaluates these claims. On the one hand, it doesn't want to deprive the defendant of his Sixth Amendment right to counsel, but of course that right also encompasses a right to represent yourself. And so, as you point out, we probably would be here if the district court had denied Mr. Hicks's request to represent himself, but instead it would have been, the claim of error would have been, I was denied my right to represent myself. And so, Your Honor, I think the district court certainly did not err in its FREDA inquiry and in finding that we will allow you to proceed forward representing yourself, but I will ensure that you have standby counsel that was previously appointed at one of the magistrate judge's prior attorney inquiry hearings. At the September 6th FREDA inquiry, the district court said, yes, we will allow you to proceed pro se, and you will continue with your standby counsel. Unless your honors have any other questions on the competency-related challenges, I will switch gears and turn to some of Ms. Mendoza's claims of error on appeal. Now, she raises 4, but this court has really, she herself and this court has really focused on only 2. The first, of course, is the quote-unquote denial of her right to be present at sentencing. Obviously, the government agrees with how this court has actually viewed this claim. It is not the right to be present at sentencing. It is the, at most, I would say, the right to confront the victims who testified at Mr. Hicks's hearing, at Ms. Mendoza's own hearing. But of course, the confrontation right does not apply at sentencing, and there is really no other, I guess, right that underlies the Rule 43 right to be present at sentencing other than confrontation and, of course, the due process clause. Sentencing courts are permitted to consider the widest breadth of information about a defendant when determining his punishment. This, of course, includes victim impact statements, whether they be in written form or have been, allocated at a prior hearing. So the court was entitled to consider what they had to offer for the purpose of imposing an appropriate sentence. As I alluded to, the only limitation on accepting information that is otherwise authorized to be considered at sentencing is the due process requirement that it be sufficiently reliable and that a defendant has a fair opportunity to respond. Now, of course, Ms. Mendoza does not argue that the victim impact statements that were given at Mr. Hicks's hearing were not sufficiently reliable. And she certainly cannot argue that she did not have notice and an opportunity to rebut those statements. She was given a transcript of Mr. Hicks's sentencing in advance of her own sentencing and had fully the opportunity to review what the victims had said and then to respond to them at her own sentencing. And she declined that opportunity. The last thing I would like to focus on is the procedural reasonableness of Ms. Mendoza's sentencing. I think your honors don't have to, get any further than acknowledging that even if the court's explanation did not permit a departure under guidelines paragraph 3B1.1, its evaluation of the 3553A factors unquestionably permitted a variance. And the court explicitly observed that absent a departure, quote, it would still vary upward for the same reasons and based on the need to reflect the seriousness of the offenses and Ms. Mendoza's role. So that ends the inquiry, regardless of whether it was error to depart upward under the guidelines. It certainly was not error for the court to have varied upward, and the court explicitly said that it would do so, and therefore any error was harmless. Unless your honors have any additional questions, I will rest on.
Okay, thank you very much.
Thank you.
All right, we'll hear from Skelton, I guess.
Thank you, Your Honor. I'll address the government's argument that any procedural error was harmless. In this case, that is not the case. What we have is sort of interlocking errors. The enhancement or the upward variance under 3B1.1 and the misapplication of the 3553 factors, all of these together exist to such a degree that that we cannot say that this error was harmless. The government's argument is essentially that the judge said one sentence that he would impose the same sentence anyway. But what we saw is his reasoning under 3553 was double counting of 3553 factors, and 3B 1.1 did not apply. The commentary to 3B 1.
Did he allude to any facts that were not what you would call double counting? Didn't he allude to the fact that these were personal encounters that deprived these people of money to their face, so to speak, and found that somewhat egregious?
He did allude to that, Your Honor, and with respect to that statement, he said that a guideline statement would be, or excuse me, a guideline sentence would be appropriate because, of course, Ms. Mendoza's trial counsel had asked for a below guideline sentence. So when he said exactly what you said, and that was specifically tied to a guideline sentence would be appropriate as opposed to a downward variance. So his upward variance explanation simply is double counting and is a misunderstanding of 3B 1.1, where she simply was using administrative decision-making that did not decide what to do with the funds. It was not present to any extraordinary degree.
Okay. Thank you very much. All right, Mr. Burnham, you have some rebuttal?
Thank you, Your Honor. Counsel for the government focused on the offense conduct, so I'll comment on that and on the trial defense. To the extent one could understand what Mr. Hicks' defense was, I would summarize it as follows, that it was all real, that he really could help these people cancel their mortgages if they just followed his teaching. And we know from several sources that that wasn't just a story. He really believed it. We know that in at least two ways. One, in the Ferretta hearing, we know that he paid money out of his pocket to a retained attorney, my predecessor counsel, to file discovery requests for some completely imaginary tax documents he alleged were in the possession of the Attorney General and that he thought would break his case wide open and show everybody that he was innocent. He really believed that, and he said as much to Judge Chuang. Secondly, the expert report that I submitted as standby counsel at sentencing specifically said, in the opinion of Dr. Boss, he was not faking. He believed what he was doing was real. So powerful were his delusions. And that fact, which is really uncontested, has at least three hugely significant
He
legal
also, during his defense, didn't he rely on the fact that his clients gave him powers of attorney to make decisions for them, and he put in the consents that they signed and so forth?
He did, yeah, very much did, Your Honor, and I think that actually supports the point I'm trying to make.
Well, it may support it, but the point is, it's a theory of trying to avoid liability, and he had thought it out, and he pursued it with questioning.
And he really expected the jury to accept that and was genuinely surprised that they didn't. And the three consequences I think that leads us to is that if that's really true, he's incompetent, legally insane, and not guilty of fraud. There's no fraudulent intent. If he genuinely was so deluded, he thought he was doing something real. And finally, with 5 seconds, if I can take maybe 15 more seconds to conclude, it's been suggested a couple of times that Judge Chuang was in some sort of impossible position for which there were no good options. And I very much contend that there was an obvious and good option. Mr. Hicks could have been sent to FMC Butner. This happens all the time. He'd be treated there, very possibly put on medications that could help him. And folks, sometimes we've all seen it. If people get their proper medications, they turn into different people. That's what happened in the United States against Chapman, a case in this court that I was counsel in, where for 5 years a defendant was incompetent. He got on meds, came to his sentence, pled guilty, accepted responsibility, and served his sentence. And the case was concluded. That could have happened here. That should have happened here. Thank you.
Thank you. All right, Ms. Skelton and Mr. Burnham, you're both court-appointed, do I understand? Yes, Your Honor. I very much like to recognize that service. We don't overlook and take for granted how important it is to our system, and thank you very much for your good service in this case. We'll come down and greet counsel, and then we'll adjourn court sine die.